So please tell us, if I don't want someone to steal it, what do I do? Please put your hands together for him.
Thank you very much, Mr. Chairman. Thank you. I beg your permission to stand on existing protocols. Thank you very much, MC, for that generous introduction. And I want to thank Mr. Okejiri. He's really laid a solid foundation. He's made my work really easy, because I'm looking at securing international intellectual property protection over information and communication technology products and inventions. Please, is my slide up? If you just put up my slide, they are just PowerPoints. They will help us to quickly progress along the line of what I'll be talking about. So my name is MARX IKONGBE. I'm a legal practitioner. I'm the principal of Ever Law Associates, an Abuja-based law firm. And I particularly specialize in IT. I'm trained by the World Intellectual Property Organization and have some competencies in registering international intellectual property production. So this is the last page. Could we go to the first page, please? Just let's take it from the first page. So, Mr. Okejiri, I won't belabor the point of what intellectual property is anymore. I'll just try to make this very visual and very illustrative of the concept, because intellectual property, even amongst lawyers, is a very abstract subject. It's the kind of subject that could make people go to sleep. Believe me, somebody who is having sleeping problem, just put him before an IP talk, and that talk alone will solve that problem. So I'll try to make this very lively so that you don't get to sleep off on me. Although, of course, if you want to sleep off on me, I'm sure soft ability would help me to give you a little whack to get you back on track. So we'll just start. We'll just look at, what the concept of intellectual property is. Like Mr. Okejiri has said, essentially, property are of two types. There's tangible property, is what you own, your house, your car, and all of that. But there are some things that are not tangible, but they have a lot of value attached to them. For instance, your reputation as a business person. Over the course of time, that reputation becomes something that even becomes more valuable than your regular stock of goods. It becomes a lot much more valuable than anything else you can place your hands on. For instance, I always give the example. People always think there's a company called Coca-Cola Nigeria Limited. But in reality, there's no company called Coca-Cola Nigeria Limited. There's a company called Nigerian Bottling Company Limited that owns the license to produce Coca-Cola products in Nigeria. So you can imagine that between the license they own to manufacture Coca-Cola products and all the depots they have and all the trucks they have and all, which do you think is more important? If today they say they should change their name and somebody else begins to produce Coca-Cola and Sprite and Fanta, and they begin to produce something else and give it a new name, of course people just migrate, because when people go to a shop, they won't say, give me that soft drink from Nigerian Bottling Company. They'll say, give me a bottle of Coke, give me a bottle of Fanta. So you can see that that becomes more important than the company itself as time progresses. So please, if I'll just have the slide. If you go to the second slide, sorry. Second slide. Yeah, so we'll say, how important is intellectual property to African ICT proprietors? Proprietors simply owners, producers, manufacturers of ICT products. And we're saying, can ICT take Africa out of the doldrums? Like Mr. Okejiri has pointed out rightly, India has made effective use of ICT. And we can see that today India is among the BRICS nations. India is one of the fastest, most aggressive growing economies in the world. They have really used IP to their advantage. And of course, Africa has to take a leave from that. Please move to the next slide. So we say yes, like I've explained, rights that exist, reputation, goodwill, creative ideas, the look and feel of a product alone has a very important component to play. For instance, this soft ability I'm standing on now, the look and feel of it alone is, something that you walk in. When I walked in here, I kept looking at it, I kept wondering what it was, and then when he came to present about it, I was really amazed. So look and feel is also something that is very, very, very important and could go a long way in making or breaking a business. Then the next slide. Then I'll say quickly, what are the types of intellectual property rights? He's done a lot of them. I'll just quickly move and summarize them. Copyright essentially protects original works that have been fixed in some form. Keywords there, original, simply means it is new, it is not copied from anywhere else. Works means that it has gone beyond merely a conception and an idea. It has been sweated out. It has become something tangible. It's not just because, for instance, anybody can have an idea about writing a book about a hero who was exiled from his land and who came back, and intruders had, aliens had come from Mars, intruded into his place, changed the social order, and he committed suicide. Anybody can write a book on that. But the moment Chinua Achebe wrote a book on that, his own idea crystallized. He now had a copyright in that book. Anybody can pick the same concept and write another book based on that, but not use Okonkwo and not use Ebubedike and all the things Chinua Achebe used, and the person would be right on point. But if the person begins to copy and maybe just changes the names, uses exactly the same setting and all, then there will be an issue of copyright. So that's why it works. It means that something has been done on it. It's not just in its bare form. Then fixed simply means that it has been put in a form that can be appreciated by a human, by human perception. So writing down is one way of fixing. Recording or any other means is another way of fixing. Presenting, preparing a slide like I've presented, where even I had to stay up practically all night because I'm not an IT person, is also a form of fixing a copyright. Then secondly, trademarks. Very, very important. Must be distinctive and it must not be descriptive. Distinctive simply means that a trademark must be able to, it must stand out apart from what it is being affixed to. The opposite, simply to understand distinctive, is that it shouldn't be descriptive. And a simple example is that the word Apple, for somebody who is selling computers, is a distinctive trademark because it does not describe the product. But if somebody is selling fruits or has a grocery shop and says the trademark for a shop is apples, it will be describing the goods that are there. And it will not be fair for other apple sellers not to be able to use the word apple because somebody has monopolized that word. So it has to be distinctive. It has to stand apart from what it is attached to. Then deceptive simply means that it should not state qualities that it does not possess ordinarily. Then we go to patents. Patents actually, is in the field of inventions, technical inventions. An invention, of course, is a technical solution to a challenge, to an existing challenge. But the important thing about patents, you must notice this: patents is not always something new. It can be a little improvement on something that already exists. For instance, taking soft ability, for instance. If I look at soft ability and say, look, soft ability is okay, but perhaps the lecturer gets tired and he needs to sit down. Can I just put something that he can pull out and sit on while he's lecturing? It means that soft ability has a patent already. But just because I made that slight improvement, I can patent that slight improvement. So, and of course, a challenge as well to IP professionals. Please, patent actually, the documents are always available for you to study. You can even go online now. You can browse patent documents from the US. You can browse patent documents on the World Intellectual Property Organization database. You can look at those things and pick something out of it and then just re-engineer it a little bit. And you have your own patent going. Or you can pick a patent from there, look at it, it has expired because patents last for a fixed period of time. And you can decide to just, make something out of it. Because a lot of patents are unfortunately not used. So we say patent must be novel. Novel simply means that it must be new. It must possess an inventive step. An inventive step means that you must have done something beyond what the average person who is familiar with that field of endeavor would know. And then it should be capable of industrial application. Simply means that it must produce something useful at the end of all your troubles. Then industrial designs essentially speaks about the aesthetic features. The things you can see physically of a product. That's what we call industrial designs. They just make the product more appealing physically. So for instance, looking at soft ability now that has become my model for description. You just look at the way it looks. Look at the chrome they used and all. It just gives it a distinctive feel. So that's actually what an industrial design does. You protect that so that nobody else just picks the look and feel of your product and then replicates it. Of course, things like, it's been argued as well that surface things, for instance, like the front page, the profile page of Facebook, the way it looks, the unique way it is organized, is also the subject of an industrial design. In America, they call them patent designs. Then we say it must be new or original. That's straightforward. And then it must appeal to the eye. It's something physical and visual. Then my next slide, I just want to give you an illustration. I don't know, most of you have wondered, how come Steve Jobs named iPad? Today, I'm going to explain to you finally what iPad stands for. Like I told you initially, my name is MARX IKONGBE. So I'm looking at it. Let's say, for instance, I want to give a practical example now. I decide to design a new tablet device. And of course, because my name is Ikongbe, I name it Ikongbe Pad. And for short, I decide to call it iPad. So, if I do something like that, so yes, so that's iPad. So if you have an iPad there, I saw somebody snapping an iPad here, make sure you pay me royalties at the end of this session. So, but practically, these 4 areas of IP I've spoken about are not exhaustive. He spoke about so many other areas: know-how, trade secret. You have heard about Coca-Cola, that they have a secret formula kept, in a secluded place where they guard it and all of that. Actually, those things are true. Sometimes you don't want to release because a patent means that you have to reveal all that it took you to come back to that invention in a way that anybody else looking at it will be able to produce that product just from your written document alone. But sometimes you have an invention that you don't want anybody to know about at all. So it's wiser to use trade secrets rather than using patents to protect it. So there are different ways to protect, but I'm just giving a simple example. If I do a new tablet device, for instance, the instruction manuals of that device, and then also the algorithms, technical people will understand that the software codes used to write the software that runs that tablet can be protected by copyright. At the same time, the logo and the distinctive name of the device, which is a Ikongbe Pad or iPad for short, you can trademark that along with the logo. Then maybe the shatterproof plexiglass screen that makes the device extra strong and durable. You can patent that as well. And then the general shape of it, maybe it has a fine shape, with nice color strips behind. You can get an industrial design over that. And then of course I can say that the chemical formula for the liquid wipe that cleans the screen and refreshes it and removes every scratch from it, I'll hide that in my safe deposit box with First Bank. I won't reveal that to anyone. So that's just a way that one product can have different IP rights acting on it at the same time. So please, let's look at the next slide. Let's move quickly. MC, please, you just clock me. If I get to 10 minutes, just give me a wave so I can make judicious use of my time. Oh, I've passed 10 minutes. Wow. Then let me rush up. So we said intellectual property and ICT products, simple and straightforward. The very nature of ICT products make them so intertwined with intellectual property that it is difficult to separate them. One of the clearest examples of ICT of intellectual property is actually ICT products. They are always almost somehow related to intellectual property. Then we'll move on to territoriality and international protection of IPR. Sorry, territoriality is a big word. Let me break it down. Simply means this: IP rights are given by different countries and they only apply within the bounds of that country. So if I do my Ikongbe Pad, for instance, and I register the trademark in the trademark registry here in Abuja, it means I'm only protected in Abuja. Anybody can go to Benin Republic and do Ikongbe Pad and sell it there as well. So it means if I want to be protected in Benin Republic, then it means I have to go to Benin Republic and also register the trademark there. So I mean, for IT products, for instance, they go around the world in the twinkling of an eye. Before iPhone is released, Nigerians have already bought. So imagine what headache it would be to have to go around every country on the face of the earth to register your IP right before it comes out. So then the other option is this: why don't I just damn counterfeiters and competitors and just do my stuff? Let's all just compete and let my quality speak for itself. Some people make that argument, but no, that argument is not right, because IP rights are on the basis of first to register. So if you have an IP right and you say, I want to sell it in India, but I don't have time to register it in India, let me sell it, let the Indian boy counterfeit it, and let's compete in the market. The Indian boy can do one thing that will not lock you out of the market. He will just go to India, register that trademark, and that will be the end of it. You will no longer be able to sell your product in India. Actually, when I talk of Ikongbe Pad, actually that story has really happened in India. Somebody registered a trademark called iPhone, I-F-O-N-E. So when iPhone came to India, they've been having serious battles getting into the market there and not breaching the IP right of Apple. So like I said, why don't I just walk ahead to trademark registry here and then register iPhone 8? Since I know that one day Apple will do iPhone 7 and they'll do iPhone 8. So I can just block their market. So by the time they come, they'll meet me. I've already registered iPhone 8. Then I say to Oga, give me $25 billion and I can release the iPhone 8 trademark to you. But as we go further down, I'll tell you why that cannot be done, because that's actually a very bad practice. It is called trolling in IP parlance, just like a troll. So then the next thing is the actual international API systems First thing you must note is that when we say international intellectual property systems, the reality still remains that IP rights are always given and enforced by a country. There's no one place you can go to and get one right, and then it's just enforceable automatically all over the world. So what the IP systems do simply is to create a structure that helps you to have a uniform way, so that with one series of activities, many countries can recognize and give you protection in their own countries. So we'll go to the substance of these IP international protection systems. Number one, copyright. We have three broad protection systems. The Berne Convention is a convention, of course, done in 1886. It has been reviewed severally. The current version is 1971 version that was agreed to in Paris. The Berne Convention simply defines what a copyright is and states that any country that is signatory to the Berne Convention should automatically do what we call national treatment. Give the same level of right, so far as copyright is concerned, to member of any other country who is part of the Berne Convention as well. So under the Berne Convention, you don't need to do anything to protect your copyright. Once you have produced your product, you have put it in a fixed form, that product is good to go. So even if you go to America and somebody infringes on your IP right, you can sue even without registering it in America. So really the Berne Convention is the closest to having a worldwide intellectual property. For instance, if you have heard about 50 Cent, 50 Cent did a movie called Things Fall Apart. He had to pay Chinua Achebe, if I remember now, close to $50 million just to get the right to use that name as the title of his film. Because he wrote the book here in Nigeria, but because of the Berne Convention, the applicability of the book in the US was upheld. Then we have the TRIPS agreement. TRIPS agreement is the agreement on the trade-related aspects of intellectual property. It is manned by the World Trade Organization. It simply helps to expand the protection of copyright from merely the old forms of written works. Berne Convention was done in 1886. TRIPS agreement in the 90s, when internet came up, they said, look, this is a new phenomenon. We have to find a way to also cage this within the bounds of copyright law. So the TRIPS agreement extends the application of copyright law to cover things like internet and all of that. Then we have the WIPO Copyright Treaty. That's WIPO Copyright Treaty. It does the same thing as well. It particularly protects the transmission of information over the internet. So for instance, if you copy something off a page on the internet and you save it to your system, you actually have infringed the copyright of the owner of that article on the internet. Of course, we all do it. So we are all guilty. Then trademarks, we have the Madrid system. The Madrid system is simply an agreement where a lot of nations came together and said, look, let's agree that when we register a trademark through one process, all of us can at the same time give protection to that trademark. So what happens is that you go to the World Intellectual Property Organization in Geneva, you register your trademark there. Then they transmit it to the different countries that you specify that you want protection in. And then, but those countries will still examine and give you protection based on their own system and their laws. Then we have the Paris Convention and the TRIPS agreement. Essentially, these agreements help to protect what we call well-known marks. For instance, Apple, iPhone is a well-known mark. So if I decide, like I said in the other example, to go and register iPhone 8, and Apple comes into Nigeria and I want to sue them, they can come under the protection of the Paris Convention and the TRIPS agreement to say that, no, we are a well-known mark, and you knew us before you went ahead to do what you did. Then, of course, patents, we have the Patent Cooperation Treaty. It's an agreement that allows you to register patents in over 140 countries at the same time by following one process. But of course, like I said, you still have to go back to those countries individually, and they may give you or refuse protection based on their own laws and their own requirements. Then we have the industrial designs. We have what we call the Hague system, where you can use one process to deposit a pattern of your industrial design, and you can get protection in close to 60 countries in the world. Then we have the organizations that regulate intellectual property internationally. We have the World Intellectual Property Organization. It's an organization, it's a part of the UN based in Geneva, and they coordinate generally all that has to do with IP rights. We have the African Intellectual Property Organization, which is an organization of 16 francophone countries in Africa. What they do is that they say, look, let's come together. Once we give anybody a right, let it apply in all of our 16 countries. Then we have also the African Regional Industrial Property Organization, which is for, say, Anglophone countries. But unfortunately, Nigeria is not a part of any of these organizations. Nigeria is still standing alone on its own. Then finally, as I round up, since I can see that the MC is already on my neck. Emerging areas of IPR. One important thing I want to point out to drive home the necessity for the issue of protecting your IPR is that domain name protection is one very important area now. Somebody can just wake up and register www.cnn.ng because it's not cnn.com. Anybody seeing it to just think, oh, CNN now has a Nigerian website. But, that would be an infringement. So there's a mechanism for protecting that. That is called cyber squatting. You take somebody's name and you make a website out of it. Or there's what they call typo squatting. You do a website that looks close to somebody's website. It's not that there's just a little misspelling. But somebody looking at it, for instance, www.googie will think that is google.com, and he can easily be misled. So there's an organization called Internet Corporation for Assigned Names and Numbers that has set up what we call the Uniform Domain Name Dispute Resolution Policy to help protect against such kind of activities. Then finally, I'll round up, go to the third before here, exactly this slide. I'll round up with this story. It's a practical story that shows us why ICT firms in Africa must take intellectual property serious. It's the case of Konga and Jumia. Konga is owned by a Nigerian. Jumia is actually owned by Germans who came to Nigeria. They came in before Konga into the e-commerce business. When Konga came into the business, Konga had a lot of money. He had just raised $70 million to start the business. So he was aggressive. He was marketing. All the staff from Jumia were running to him. He was paying better salaries. So Jumia approached him and said, Oga, please, instead of fighting ourselves, can we just cooperate and merge and form one company and just put out our services together? Konga considered and said, no, I don't want to. I want to go on my own. So because Jumia saw that they couldn't get their way that way, they now went behind the back to do something very funny. They decided that the way Konga is going, it's better we contain them in Nigeria. If they go out of Nigeria, they would overpower us. So what they did was that they went to other African countries and registered the Konga domain name. So for instance, Kenya, they have konga.kn. Then the one that sparked this case is the one that registered in Seychelles, konga.sc, which SC is just like NG, the country code top level domain for Seychelles. So they registered Konga all over, meaning that if Konga goes into those countries, before they can use that domain name, they have to settle Jumia first and foremost. And of course, we know that would be impossible. So unfortunately, Konga went to World Intellectual Property Organization to use the Uniform Dispute Resolution procedure. But unfortunately for them, they lost the case. Why did they lose the case? Is what we are saying here exactly. They never registered the Konga trademark in Nigeria before going there. And that was why they lost that case. Unfortunately for them, though, we must give them credit. They actually had applied to register the name in the trademark registry here in Abuja. But as inefficient as Nigeria can be, for 2 years, the application was pending. It was never registered. And that's how they lost that case. So we are using that to make an appeal for anybody who is here, who is in government, like my friend here. Please, let's talk to government about having a more robust IP regulation framework in Nigeria. The trademark registry, to say the least, is in a sorry state. Do you believe that in trademark registry they still use manual records? You file an application and then people sit on a table, they bring out records and they have to be flipping cards to check if there's a conflict between your trademark and what is already existing. How would that work, for God's sake? So please, we beg you and anybody who has influence in government, please help us talk to government. We need a robust
thank you very much
for IT presentation. So thank you very much. That is it. And then finally, please put up a disclaimer. Please, this is not legal advice. If you need legal advice, you know what to do.
Thank you very much.
Contact details are there. So thank you very much. Thank you for being a good audience. I wrote that before I met you, but as I met you, you have proven to be a good audience. Thank you very much. And thank you, MC, for being a good MC. And thank you, Chairman.
Now, who says barristers do not give bribe? He just gave me bribe. Thank you, MC, for being a good MC, because I didn't cut him. Please.